is Laetitia de Montalivet. I'm the Regional Director for Europe for Arbitration and ADR matters at the ICC Court of International Arbitration. And of course, we are deeply sorry for being unable to, due to COVID, to be physically present in Tbilisi and not joining the GIAC days, because as you may know, this webinar is part of the GIAC days. But we hope to have soon the opportunity to meet all again and to be in your wonderful country. 2020 has been quite a special year for our soul. Worldwide, we have experienced unusual circumstances never before seen, and the world of arbitration has also changed in many ways for parties and for institutions. And this is why this webinar is dedicated to the ICC Court and the Georgian International Arbitration Center experience at times of COVID, dedicated to the new reality in arbitration caused by pandemic. For the ICC, actually, it has been quite a difficult challenge. The ICC organizes, on average, every year about 150 court sessions in multiple occasions in the globe, in the occasion of which more than 500 awards are scrutinized and thousands of decisions are made. Each of these court sessions is involving from 3 to 50 court members, depending on the formats. And so we had to completely reorganize our internal work so as to allow everyone to work remotely and all court sessions to take place by video, so that in spite of the pandemic, the work of the court has proceeded without any added delay for parties. Equally, our training activities, which are so important for the development of future generation of arbitrators, have continued online in all continents. We are nonetheless aware that in many emerging countries, the personal contact and exchange is extremely important in the development and training of the new generation of arbitrators, and we will need to resume personal presence as soon as COVID permits. COVID has presented even greater challenges to arbitrators and parties, and all players are becoming more and more familiar with technology. And technology will continue to improve so that even long and complex evidentiary hearings can now be organized remotely in a stable and secure manner. The ICC is providing technical support to party, and the ICC Hearing Center can assist the organization of virtual hearings. And we will soon offer a new platform allowing parties to upload and manage their submissions and exhibit online. And there is no way back. Technology will remain a fundamental aspect of the efficient conduct of any arbitration. And as technology improves, it will more and more be so. Holding a hearing online should no longer be considered as an exception or a departure from normal procedures. It will be more and more be considered as on the same footing as a physical hearing, and will become an item on the agenda of any case management conference call. You might also have heard about our new rules that will come into force on the 1st of January 2021, maximizing the efficiency of arbitration proceedings. Its flexibility and its transparency was and remain a central theme for any arbitral institution. I will stop here, but let me thank Ketevan Betaneli. She is the senior knowledge management lawyer at Freshfield in Paris, but she is also our court member and the chairperson of the GIAC Arbitration Council. She is the one who had this idea of a dialogue between the two institutions at first, and then I would like, of course, to thank Beka and GIAC, that you all know, but he is the Secretary General of the Georgian International Arbitration Center, for having welcomed this idea and for the great spirit of cooperation he accepted to have between our two respective institutions. I would like, of course, also to mention ICC Georgia, dynamic national committee, for great support. So with any further ado, I'd like to give the floor to Ketevan if it works. Keti, the floor is yours.
Hello?
Yes,
Yes, finally.
Yes. We hear you.
I'm so happy to be here. Actually, all these delays because of me and because of not coping with the technology, and I have third parties like my firm to blame for not having Zoom. But okay, so yes, now I will question how efficient the technology and doing live remotely is after this experience. I was sweating a bit for the past 20 minutes. That's not very little. Okay, anyways, thank you everyone and for joining. Thank you for the speakers. I really apologize for creating a mess out of this, but I hope that we'll get back on track very quickly and this will be an interesting discussion. After the Laetitia's introduction, I want to do a more specific introduction of the actual session and the issues that we will be discussing. As you all know here, our lives have changed since March with the start of the pandemic, which has impacted the way we do things every day. The consequences of the pandemic are likely to stay with us post-pandemic. The pandemic has already, for the past 9 months, affected our professional lives, not only personal lives, and has probably taught how to handle things differently in these extreme circumstances. At first, personally, for me, when the pandemic started in France, it was March when we had the lockdown. I was a bit scared and very skeptical of how can we do things remotely? How can we do everything from home? Is this really doable? And already very soon, we looked to the arbitral institutions to see how actually they would handle things and what they are to tell us about the situation and how are they finding the ways from these difficult times not to interfere the work that we do. 9 months since March, and we're still gathering here virtually with some technological challenges and failures on my part. And we're here to discuss how the arbitral institutions have been handling the pandemic and kind of looking back and looking forward. The many questions we have had at the beginning, and I think we still have, is have the arbitral institutions been efficient enough in handling the situation? Have they efficiently handled the challenges and on time? Could they have done things differently, faster? Could they have, been more conservative, more innovative, etc.? And can they do more? And what can they do to improve our lives further in this situation? So in order to tackle these interesting issues that are of concern to the arbitration practitioners, we have speakers from 2 arbitral institutions, as has been already mentioned. And you all know we have a speaker from the ICC and we have a speaker from GIAC. So it's very interesting to compare the perspectives of the major international arbitral institution with the regional arbitral institution from Caucasus. And then in order to add flavor to this, we have 2 speakers from private practice. One is based in Paris and the other one is based in Tbilisi. So it is a really international panel. And at the end of this discussion, we will have Q&A. So we hope that we will have an active participation from the audience. A few more words about the speakers before we get into the actual discussion. So our first speaker will be Hjordis, who is from the ICC. She joined the ICC Court in 2007 as a deputy counsel in the German team, and she now is the counsel for Eastern European team. Hence her relevance. In addition to being part of the ICC Secretariat, she handles the cases that concern Georgia and the greater region. A few more words about her. She's Icelandic qualified. She has previously worked at a law firm in Reykjavik for 6 years, and then she had moved, where interestingly, she was handling cases involving 2008 financial crisis, which, now reminds us of certain old difficult times where we stand today. And then she did the MITS program in Geneva, and now she's based in Paris. Our second speaker will be Beka. India, the Secretary General of GIAC, who is based in Tbilisi. He is the founder of GIAC. He took the lead in creating the GIAC arbitration rules and GIAC Arbitration Institution for more than 6 years now, 6 years ago now. In 2014, he is Georgian qualified, and he also did the MITS program like Jordi. So that is what's uniting them in addition to working for 2 arbitral institutions. And he was previously working in both public and private sector, including the Ministry of Justice, where he was advising, he was an advisor in division representing state in arbitrations. And now, then our next speaker will be, now we move to the practicing lawyers, and our next speaker will be Kirsten Dinsky, who is a partner in White & Case's international arbitration practice based in Paris, where she has transferred from the firm's New York office in 2012 after having spent the first 3 years with the firm there. As for her connection with Georgia, Kirsten was a member of the Commission for the Revision of the GIAC arbitration rules, so she really knows how the GIAC rules work, and has for some years now working on the cases involving Georgia as a state, as a party. She's working with the Ministry of Justice of Georgia. And our last speaker will be Tamta Ivanishvili, who's based in Tbilisi, and she's a partner at BLC Law Office, a leading law firm in Georgia. Tamta has extensive experience representing corporations as well as state actors in complex litigation, investment and commercial arbitrations. Tamta is a member of Georgian Arbitration Association and is actively involved in various reforms and initiatives aimed at promoting Georgia and developing alternative dispute resolution system in Georgia. And lastly, I will be moderating this session, and my name is Ketevan Betaneli. I'm glad something strange has not come up on the screen. I was fearing some weird nickname. So it's correct. My name is Ketevan Betaneli. I'm originally from Georgia, while I'm now based in Paris for 9 years. Before joining, and I'm working at Freshfields Brackhouse in Paris. Before joining Freshfields, I worked at Sherman and Sterling in Paris, and before that, I worked at the Ministry of Justice in the arbitrations department, also handling the cases on behalf of the state. So this is our panel, and we look forward to the discussion. As you will see, as you see already, this is a rare occasion to have the representatives of 2 arbitral institutions in front of you. So please, once we move to the Q&A, be active and ask questions. Given the format, you won't be able to show your face, as I understand. You have to put your question in the Q&A, and then we will address them. You don't have to wait until the end of the session. You can already start typing in your questions whenever you feel like, and whenever the issue comes up to you, that should go in. And I think we should kick in. One thing, which is important, I see that the session is being recorded. So if someone does not want to be recorded, please, as a party, even if we don't see you, please, you're welcome to leave if you would not like to participate in this recorded session. So I now give the floor to our first speaker, Jordis, to speak about the ICC and how ICC has been handling the cases during crisis. Thank you.
Thank you very much, Ketty. Can you all hear me well? Yes. Perfect. So I'm very happy to be here. I've been asked to take you through the different steps that the ICC has taken in a reaction to the pandemic. And I thought I might just take you through it step by step, because of course in March we didn't have a fully fledged plan. It's something that we had to do from one week to the next, so to speak. So I wanted to just take you back to March this year, when we started to get a lot of phone calls from our users and arbitrators asking us very simple questions like, are you open for business? Are you at the office? Is someone there to accept courier? And we started to get more and more of these phone calls. And this prompted our first reaction in 17th of March, which was our communication, which was published on our website, where we went through these basic things. We said we are open and operational. We are working from home. Nevertheless, it's business as usual as much as possible. We clarified that we would encourage everyone to communicate with us by email. And we even requested that new requests for arbitration be filed by email if at all possible. And we also asked the parties to let us know whenever they were dispatching something to us by courier, so that we could organize ourselves accordingly, because we had a rotating team at the offices, and so we needed to make sure that someone was there to take care of it. So this was our initial reaction to the pandemic. And then in early April, as most of you will know, we issued a more detailed guidance in our guidance note on possible measures aimed at mitigating the effects of the COVID pandemic. And there we went into much more detail as to how we could deal with the situation. One could say that the note is divided into 3 parts. First, it recalls just the general principles in our rules, and we emphasize that notwithstanding the pandemic, our fundamental principles still applied, meaning that our rules in Article 22 and 25 encouraging our arbitral tribunals and parties to proceed efficiently and within as short a time as possible. This was still applicable. And in that context, we also recalled the case management techniques that apply and have been set out in detail in our rules, as well as in guidance note and reports. So that was sort of the first part, to tell our users and our tribunals, or remind them rather of the tools that they have available. The second part dealt with the service of submissions and notifications, and that sort of was a continuation of our communication since in March. So we again emphasized that we encouraged everyone to communicate with us by email, both for requests for arbitration and other initiating documents. We also encouraged arbitral tribunals to prepare and sign terms of reference electronically whenever possible, and even awards, although of course always subject to any mandatory laws that might pose any problems there. And then finally, and this was probably the part of the note that was most appreciated by our users and tribunals, and that was the part dealing with virtual hearings. And so we invited tribunals to consider whether it was possible to proceed with hearings, notwithstanding the pandemic, either physically by taking the appropriate safety measures, or if not, by doing so virtually. And for that purpose, we set out in 2 separate annexes to the note. First, a checklist as to if they were to have a virtual hearing, what they needed to consider and to think about. And then in another annex, we set out sort of a model PO, which the tribunals could use, setting out the different provisions that need to be set out before such a hearing. And this was anything from logistics, such as who is participating and from where, what is the platform that you will use, how will you deal with privacy and security issues, how will you examine witnesses, all these things that one needs to consider when conducting a hearing virtually. And I think this is what was most appreciated, and what we've seen then subsequently throughout the virtual hearings has been really used by our users. We've seen these CYPR protocols that use our model And so I think that was a very positive thing. And finally, and quite fittingly, we have now introduced our new rules that are coming into force on the 1st of January 2021. And like I said, fittingly, they deal with also electronic submissions and virtual hearings. I should note that that's not a direct consequence of COVID, rather that is something that was underway even before, but nevertheless is a natural consequence of where we are. The changes deal with a lot of different things, but amongst them is general efficiency, and that is electronic submissions as well as virtual hearings. And I think maybe without going into too much detail there, maybe in terms of the virtual hearings, as was put out in the guidance note, our current rules, they don't prohibit virtual hearings. However, they do contain language that causes some doubt, because it says that if one of the parties requests, the tribunal shall hear the parties in person, which one could construe as meaning that there needs to be a physical hearing. Now, in our guidance note, we suggested that one could understand this as not necessarily having to be a physical hearing, but simply a live adversarial exchange, which could take place through a video conference. And this is something we have seen now under our current rules, which we might then discuss later during our Q&A. But nevertheless, the new rules in Article 25 and 26, they now remove this debate altogether by clarifying without any doubt that the tribunal can, after having consulted the parties, convene either a physical hearing or a virtual hearing, and does not need necessarily the consent of everyone, as long as the parties are consulted and all relevant circumstances are taken into account. And I think maybe I'll stop here, but look forward to the discussion later on this. Thank you.
Thank you. Now we give the floor to Beka to give the GIAC's perspective.
Thank you, Katie. And before going to the steps and to overviewing the steps and the activities we have made during this year because of the pandemic, I would like to express my gratitude and thank to ICC Court of Arbitration also, and especially the representatives, and especially to Laetitia to organizing this very wonderful event despite of the very small technical problems which might always happen, and we are people and we have to be care of that, and we have to be preserved on that. Anyway, it is really good opportunity, and as Laetitia already mentioned about that, I want to underline that this is the second time the GIAC, Georgian International Arbitration Center, is cooperating and organizing the joint event with ICC Court of Arbitration, and it is I can proudly say that this is really excellent example of cooperation, and we think that with the big international arbitrations, the institution, and the young new developed regional arbitration center, and I think that this kind of event is both is beneficial for both of us and for development arbitration as well. So also, it is true that I want to show you how we acted from very beginning of pandemic and what we have done against the situation which arise due to the pandemic. But in general, I would agree always that the mineral consideration was same. But issue is that it is not new for us that this kind of discussion has been done from very beginning, and in many online events we have heard about the pandemic and arbitration. Likewise, the expression that you are on mute is very trendy now, and everybody is using that. So the topic of arbitration and pandemic is also very popular, and still it is going, and we are talking about this. But still, there is something to talk, and that's why we are doing that. And I think that the audience, they will be interesting to hear what is from these both institutions, what is from our perspective has been done and what we are doing and what we think we will do in future. As for the beginning, I have to say that the main concern in the process of arbitration was taken to the arbitration hearings, of course. And still hearings and distance hearings is actual topic still till now. I have to mention that the very beginning from March, when the virus was very aggressive, what we have seen and was new for also for scientists, our government, like other governments, has imposed the emergency situations, and there was the strict restrictions, much stricter than this second wave we are having now, and they have banned and suspended many activities. Among others, in our case, in Georgian case, was the activity of mediation and arbitration also. But fortunately, immediately it has been cancelled, and then the arbitration in our center has the opportunity and the availability to continue our cases and the disputes. But still, we are thinking what to do and how to proceed with that. For this, of course, very urgently, we adopted with this situation, and like other arbitral institutions, we adopted the rules, protocols, and other technical instructions for that. Sorry, can I say that you hear me?
Yes.
Okay, there was some kind of problem. So I was saying that we have elaborated the protocols for distance hearing, the other technical instructions, for example, instruction and guidelines how to use the online platform during the distance hearing, the details, instructions for the parties, and so on. But still, main problem from the beginning was the cases that was already ongoing before that. So there we had the cases which has been scheduled before these instructions and the distance hearing protocols, and what would happen in case the party never agree on these protocols. But for lucky us that no party has failed to agree, the agreements that they may manage to mutually made the consent on these protocols, and finally they agreed all the details of the distance hearings, and there was no other problems with that, and so in that regard we are lucky. But in another case where there was could not be the agreement between the party, it could arise a kind of problem. But anyway, there was the room of interpretation of the rules, but still. I want to mention that the protocols is very detailed, and it is dealing with the application of itself, the scope, its scope, so other details and instructions, how tribunal should identify the parties, how the experts, specialists, also the parties involved in the case, and other steps, how the network should be working, that whose responsibility is that, and also other technical issue. I won't stop in that very in details, but the main issue here, what we saw and what was under the question, and I think that without the changes in the rules, it is, and still it is under the question, maybe under the question and under the interpretation. And you know that our protocol is applicable for when it is agreed and if there is a mutual consent of the parties. Or other option, when the tribunal decides so and decides to use the such protocol. According to our protocol, the tribunal has the discretion to decide this issue. But the question, again, I will repeat, if this approach is in compliance with the GIAC rules, it can be maybe under the question. And the article which is dealing with the hearings in the rules is Article 30, which reads as follows. The arbitral tribunal shall fix the time date and place of the hearing in consultation with the parties reasonably in advance of such hearing. And another question, sentence, the arbitral tribunal shall be fully in charge of the hearings. So in this regard, we think, and the arbitral tribunal also mentioned in the award, that this article should be interpreted broadly, and that in a way that the tribunal has rights to fix the place. So under the place are deemed the possibility to fix the distance hearing. So distance hearing is kind of method of getting together and to make deliberations. So, and additionally, the second sentence of the article, which states that the arbitral tribunal shall be fully in charge of the hearings, it gives the discretion to the tribunal to extend the protocol and to apply for the distance hearing. But here, from the institutional perspective, we have to say, and I will also share the what Oris already said, that the ICC has changed already rules, and we are in the same idea that we want to, and also we have started, Katie will agree on that, that we have started working on new changes and the revision of GIAC rules. But here I have to mention that these changes are not only due to the pandemic and these distance hearings. No, of course, the last version of the GIAC rules has been adopted in 2017, and with this period, there has been some kind of technical changes, and in practice we have seen that some rules and provisions should be renovated and should be changed, and it works worsely, or it should be improved. So there is not only distance hearing, but it is one of the main issues. It will be one of the main issue of the changes, but there are other issues which we will deal, and we hope that the end of the 1st January of next year, we will have new edition of the GIAC rules. Also, I will go to finish my small presentation or overview of the steps what we have done, and so I want to mention that Katie does not like, as I guess, the platform Zoom, as I guess, but as a default we have the contract, and we are connected with Zoom and as a default we are using this program for that. But of course we are free, we are open, and we had the possibility and the experience to use other platforms for doing the distance hearings. And what about the document production and also the submissions and the filings? We have been here also very adaptable, and we are using the special online platform. The Secretariat is managing this platform and giving possibility to the tribunal and the parties, and also, if necessary, of course, the Secretariat, access to this platform. And it is very easy, it's kind of space, and very easy to change the documents, and very easy for the tribunals, and it helps and making the life easier, of course. And this is something really good when the techniques, new technologies helping, and I'm sure that in terms of the Q&As, we will deal with the idea if in future this will work, and if we continue in this way. And I think that then we will discuss much more, and I think that this technology really helps to us. Also, I have to mention that from other parts, the GIAC is also active in the other dispute settlement mechanisms and the sources. I mean, the mediation and the facilitation platform we issued, and this is also the possibility. And this pandemic has kind of made us urgent to enact and made this platform. Others is that, you know, that the not only us, whole world has built other educational and not other educational, but meetings. We are doing it already in online platform. Also, the GIAC arbitration days, it has cancelled in person, that we are having in online, and we are making different online events. And finally, I want to say that regarding the statistics, I think that it is very our experience, and it will be interesting for how it, in ICC case it is. But I have to mention that the caseload and the cases filed to us, it was depending in this year. I mean, depending on the restrictions. For example, the year has started for us. Has started quite well, so cases has been quite good, but during the pandemic period, the first restriction and the emergency period, the cases filing has stopped and reduced so much. Then after that, during the summertime and beginning of the September, and in September, October, cases was coming. But again, during the second wave of the pandemic, the cases, case loads, I mean, the new cases has been reduced. And practically in November, we had no cases entered here. So this is something that the pandemic has influenced on the activity of GIAC. So in terms of the statistics, also it has kind of impact. So in this, I will stop now, and hope I won't will not be too much, and then I will continue with quick question and answers. And now I will let Katie to continue moderating, and let us hear to other speakers. Thank you very much.
Thank you, Beka. Thank you. So now we will move to the two private practice lawyers, practitioners. From Paris first, we'll have Kirsten, and then Tamta from Tbilisi. Before we go to the speakers, I'm seeing few questions being written, which is great, that we will address later. And I also encourage you to target the questions and use this opportunity to ask Beka and Yordis how actually the institutions have been handling certain issues, and if you have any questions that they, as representatives of the institutions, can answer. That should be probably a useful thing to do. Thank you. Now, Kirsten, please.
Thank you, Katie. Just to check and to use one of our new expressions Beka was talking about, can you all hear me well? Great. It is a pleasure and a privilege to be here on this panel today and to discussing these issues. As Katie mentioned, and indeed as Yordis mentioned, today is an auspicious date. 17 March 2020 was the date that France entered its first strict lockdown. And it was also the date that the ICC issued its first communication on what will happen in, how the ICC will function and how the ICC will adapt to these new circumstances. So here we are exactly 9 months later, and of course, it being close to the end of the year and this auspicious date caused me to reflect on what has happened in my practice over the last 9 months. And for me, 3 phases have emerged. Now, admittedly, there's some overlap, but I thought that I would organize my thoughts in this way. The first I've called procedural fairness. The second I call adaptation, and the third I call new opportunities. So let's take a look at each of these in turn. First, procedural fairness. As Beka said, a key initial issue that I think all practitioners were faced with is, can my existing matters continue on the procedural timetables and in accordance with the terms of reference that have been fixed if they were ICC matters, or in accordance with the other guidance that will be fixed? This was the first issue. It was an urgent issue for my clients, understandably, and it was one that needed to be considered together with the institutions in the case of institutional arbitration. Now, given the uncertainty about the virus and its impacts, and our community's lack of collective experience working in lockdown, the first interesting thing is there was no consensus. I found myself writing applications in favor of virtual hearings and applications opposing virtual hearings. I found myself writing letters seeking extensions of time, and also writing letters objecting to extensions of time being requested by other parties. So what can we take away from this uncertainty? And I think there's a few really interesting points that sort of emerge from this. The first is that arbitration, the flexible nature of arbitration, and the fact that each case has very different and very unique circumstances, even in a pandemic or not in a pandemic, and that it is, you know, we really need to keep this sort of case-specific focus. And I think that the flexibility that we have in international arbitration really allows us to do this. And this was an opportunity that showcased the ability for practitioners to take advantage of that. The second thing that emerged quite quickly was the reaction of the arbitral tribunals themselves, and of course of the institutions of the ICC and GIAC and the guidance that they provided. And it was surprising to me when I think back on it with the benefit of hindsight. Universally, there was a decision and a consensus that emerged very quickly that things must continue. There was no suspension of arbitration processes. There was no, we are going to delay this for 6 months. There was really, you know, this sort of rapid consensus that emerged that we can and we should do this, which I think shows that the issues of efficiency and transparency had emerged long before then. In my personal experience, the two themes that quickly emerged was simply saying there's a global pandemic, I need an extension, wasn't enough. Both for the institutions and for the tribunals, they needed to see more. They needed to see some specific particularization, which I think is a reflection of the application of procedural fairness and the the flexibility that tribunals have in bringing this forward. The second was lengthy delays were generally frowned upon. Nobody wanted to delay things more than necessary, and to use the trite expression, justice delayed is justice denied. And I think that the last two observations I will make on this point is, first, I thought that tribunals used really interesting procedural tools to help manage this balance between due process and the need to proceed quickly. So we saw reasons being used and also notes to procedural orders, which is something we don't see very often, but we saw a resurgence of, and I thought that that was quite interesting and a tool that could be used going forward. And the second thing, which I wanted to pick up on, which we heard in both of the previous panelists speak, is what is the role of the tribunal and the use of the word shall. So we heard Beka's very insightful comments about, you know, what are the limits on the tribunal's authority in terms of setting the procedure and being able to take decisions in the face of a party that's objecting about a virtual hearing. And I wanted to just flag for the purposes of our discussion later that one of the amendments to the new ICC rules was in Article 22.2, where a may has been changed to a shall, such that an arbitral tribunal is now, and I'm just gonna, sorry, give me 1 second, I have the wrong screen in front of me. An arbitral tribunal now, in the new ICC rules, shall adopt procedural measures it considers appropriate in order to assure the effective case management. And this is an interesting trend towards the balance of power between the parties in the tribunal and giving the tribunal more power to ensure the efficiencies, of course, under the guidance of the institutions. And I think it's an interesting step and one that goes in the right direction for me from a practitioner's perspective. So that's it for phase one. Turning to phase two, adaptation. So as it happened, one of the very first business trips that I had canceled was a trip to Tbilisi. Well, I was not able to find a substitute in Paris for my Kinkali craving. We were able to find a way to restructure and reorganize the meetings. And so I wanted to just make a few comments about the phase before the hearing. And so I wanted to talk a little bit about some of the challenges and the lessons learned in working with witnesses and experts and really building and developing a case. So the meetings that were scheduled in Tbilisi involved numerous people, some in the private sector, some in the public sector, and they were to take place in Georgian through interpretation. And so the first challenge was, how do we take this in-person meeting setting and transform it into a virtual reality? So we had to select a virtual platform, we had to figure out how to make the interpretation work, and then we had to schedule the length of the meetings appropriately. So first, and to echo Beka and Keti's comments about the choice of the platform, we learned very quickly, in an area I never thought I would have expertise in, it really does matter. Different platforms are different people have access to different platforms, and it's worth spending a few minutes, even for the purpose of interviews or negotiations or meetings, figuring out which platform works best and how it's developed. Secondly, we were thrilled with our ability to have interpreters participate in virtual meetings and to have consecutive, although not simultaneous, translation. And to facilitate that process, one of the things that we found helpful both on all of my matters is to provide the interpreter with the agenda and some notes of the meeting in advance so they can help control the flow in the discussion, which is really well. And then the last point is I found over the last 9 months, we've had to shorten the length of meetings considerably. For whatever reason, it just doesn't work to have a whole day meeting on Zoom. It's just not possible to maintain attention in that way, and it's quite tiring. So it has sort of forced a reorganization of the way we think about the issues and how we develop a case, and we've tended to have shorter, more focused meetings in order to bring it forward. Two other points that have come up repeatedly that I just wanted to draw attention to is the availability of documents and other evidence. Now, this has been a real challenge that has been difficult to overcome. Particularly in the early phase where there were strict lockdowns, witnesses and experts did not and were not able to access, physical hard copy records and other documents that we would usually have when we build a case and determine a case theory. In many cases, we had to make very difficult decisions about, can we do without these documents? Can we make specific exceptions in order to obtain these documents, and how to go forward? I don't have any good solutions to the problem of access to documents and other evidence, and so I would welcome any suggestions that my fellow panelists or the participants in today's sessions have. The last point I wanted to make is about working with experts and site visits. One thing that's quite common, particularly in construction or commercial cases, is that you would have the expert travel to see the project or to see the site, and that has not been possible in virtually all circumstances for the last 9 months. Unlike working with documents, this was easier to overcome by allowing time for additional meetings, the provision of additional technical drawings, and even in some cases, virtual tours. Now, one thing that all of this has of course happened virtually. We've moved to our preparation for cases in a virtual setting. And so this raises the question, which is oft debated, is will we return to in-person meetings? Will I get to come back to Tbilisi and eat kinkali? And I think the answer is yes, particularly not just because of my love of kinkali, but particularly with new clients as new witnesses and new matters. I do think that there's something that an in-person rapport can help develop that we just simply can't replace. So moving on to my last and final phase, phase 3. In recent months, the thing that we have been seeing, or that I've been seeing in my practice, is increased requests for claims assessment and an increased number of disputes related to the COVID-19 pandemic itself. And I think that there are some interesting roles here, and I've seen a few questions flashing up on the screen about how are we going to manage these new types of disputes, and how are we going to, as practitioners, adapt within both the national regulations and indeed some international regulations. And I just wanted to share one example from my practice, which is in the FIDIC context. And as I'm sure many of you, if not all of you know, in the FIDIC context, there are a number of pre-arbitration steps in the dispute resolution procedure. And this also applies in some respects to investment arbitration, where you have a requirement to send a cooling off letter in for a negotiation phase. And the issue that we're facing right now is, how do we manage this early notification phase with respect to the COVID-19 pandemic? What prompts, and the key issues for me have been, what prompts a notification, and do you need to make repeated notifications? So if the government passed the law in March and you notified a dispute then, and there are new or changed laws in February, in April, and in October, what are the notification requirements for a party, and how can you preserve your rights to bring a claim in those various contexts while still ensuring that things are efficient and moving in a, without sending a notice every day, every time something changes. You sort of need to be able to find a balance there. So I think that that's one key issue we're seeing. And the second, which I've also seen flashing up in the question boxes, which is great, and I look forward to a discussion, is new heads of claim. Are aspects of the COVID-19 pandemic force majeure? Are there specific financial or other things that we need to be considering as practitioners in how we bring disputes together? And if so, what kinds of nature of arbitral expertise, other experts, mediation, etc., do we need to consider for resolving those disputes? So I will leave my comments there, and I look very forward to further discussion. Thank you.
Thank you very much. Now we have our last speaker, Tamta from Tbilisi.
Thank you, Katie, and thank you everybody for taking time to be with us this evening. I really hope that our panel will be very interesting for all of you. Georgian experience. Well, something you need to know about Georgia is that we are very personal, meeting-oriented culture in general. Our practice pre-pandemic was that every client or every counterparty, no matter whether it could have been a 5-minute phone call, everybody wanted a personal meeting. In terms of arbitration context, I think I have never even had a telephone or online case management conference prior to COVID pandemic, because we knew that there was a possibility of having at least the case management conference via telephone or online. But, everybody wanted to go and see the arbitrator in person, see the counterparty in person. It had certain special appeal in Georgia in general. So this definitely saw a major shift. And in this context, I just want to describe the two experiences I had as a practicing lawyer in Georgia during the COVID pandemic. One of it was in GIAC when I acted actually as an arbitrator, not a representative of one of the parties. And another was in the context of another institution where my firm had to act as a party representative. So the first case where I acted as an arbitrator, actually it was a 3-arbitrator panel and I was one of the arbitrators. The request for arbitration was filed in December. This was a GIAC case. So until the arbitrators were appointed and until the case management conference could have started, it was March already. So in order to understand the context, you need to know that, COVID appeared in Georgia in February, and the government started introducing gradual restrictions and lockdown measures one by one. So we didn't actually have strict lockdown until late March, early April. So what happened is that we had a non-cooperative respondent, and Beka knows this case quite well, who was trying to delay. This was the only tactics they had. They didn't respond to the claim which they received in December, early January, when there were no restrictions in place in Georgia. So when the panel was constituted and when the arbitrators met for the first time, we decided that the first case management conference would be held on 31st of March. So at this time, the respondent understood that, we were not kidding and the case would go on with or without him. And he decided to start participating at this stage. So our first case management conference was scheduled for 31st of March. And a week before this, we received a letter from the respondent asking to delay the case management proceedings because he didn't have time to find a lawyer due to pandemic. He failed to be adequately represented and stuff like this, the usual stuff. I know all of us, especially Kristen, as she mentioned, is familiar with these arguments. So what we issued an order. We decided to take a very proactive approach and we decided to go on with the case, and the case management conference would be held on 31st of March. But what happened was that on the 30th of March, the government of Georgia introduced this now infamous ordinance saying that any commercial activity was banned on the territory of Georgia. So we had an order issued by the arbitrators actually saying that the case would continue, and on the same date, actually, the government introduced this regulation. So we had no idea what to do because any reasonable interpretation of this law would suggest that, why would someone care whether you would hold a case management conference from distance online, because it wouldn't impact the pandemic or mobility or something which would have had significance for these issues. But we were compelled to delay the proceedings. We issued the order stating that the arbitration proceedings would be suspended until the relevant governmental regulations were clarified. So to give credit to Georgian Institute of Arbitrators and the Beka and SOPO, and we all know these people, they were very active. They got in touch with the Minister of Justice, and they amended the ordinance very quickly, saying that arbitral hearing, if the hearing was conducted online through distant measures, were allowed. So after this, we were sort of allowed to continue with the arbitral proceedings, but the respondents sort of continued in the same manner, because from March till April, I think the lockdown was the strictest in Georgia. We have not had such strict lockdown after that. Even now, I mean, the measures we have in Tbilisi currently are much milder than what we had in April. At some point, there was no movement, even through cars allowed. Only the cars having special permits were allowed to move into the street. So of course we were receiving, like every week we were receiving a different motion from this respondent, basically after each new regulation, saying that, you know, I'm still not able to find a lawyer, you know, I'm impeded by this pandemic to adequately free. And actually this was not a sophisticated party, as you would guess by now, but his arguments were actually would have been the core of due process rights of each party under normal circumstances. So what you do, our panel actually decided not to suspend the proceedings, and we decided to go on with the proceedings and hold the hearings. But our primary argument in this setting was that the party received the claim in December. Had he received the claim in February or March or April, of course, the tribunal's approach would be much different from this, because it would be very difficult for every tribunal, for any tribunal, to refuse the request for postponing the hearing if the party is saying that, you know, there is pandemic in the country and I cannot find a lawyer to adequately represent me. So the primary argument which helped the tribunal in this case was that it was evident from the very beginning that the party was in bad faith. All they wanted was to delay the proceedings, and they were not cooperating from the very beginning. So we were still very cautious in this situation, because every our order was argumented like with several pages. You know, you don't see procedural orders with such detailed argumentation often. And we knew that, you know, most probably this case would go to the Court of Appeals for annulment or some similar proceedings, just saying that he wasn't allowed to be adequately represented. So, and we always had this in mind when adopting each and every procedural order. Fortunately, everything ended well in this case, but you know, this question always pops up in my mind. I mean, what would happen if the proceedings would simply start, I don't know, 2 months after? Another case which was very important for me as a practitioner involved, it was an international commercial arbitration. Actually, this was a cross-jurisdictional dispute where the lawyers of both parties were from Tbilisi. So this was a Georgian law-governed contract and relationship. So the lawyers were placed in Tbilisi. However, there were several jurisdictions involved in this issue. There were a number of witnesses all over the world, Germany, Ukraine, USA, UK. There were some arbitrators from Caribbean. So initially it was planned that the hearings would be scheduled in Tbilisi in summer. However, of course, we had like months and months of preparations ahead, and it was obvious in March already that there was no way that we would be able to hold hearings in Tbilisi with everybody present in the city as it was originally planned. So what we did, and actually I'm very proud of how parties cooperated in this case, we actually drafted our own protocol for online hearings before the institution actually issued any guidelines or instructions on how to do it. And the issue and the problem in our case was that the arbitrators had very strict requirements what we should have done in order for them to be comfortable in conducting this complex case virtually via online. So they had their own requirements, which we had to satisfy, and which was actually very costly and challenging for the parties to comply with. And I will give you several examples. For example, there was a requirement that the venue should have been very neutral, not the offices of any of the lawyers involved in the case. And there was other technical reason for this also, because they wanted the room to have microphones, at least 2 cameras, for them to see all corners of the room to ensure that there was no undue influence or something like that in the room happening. And every time the witness was questioning, there was at least 2 lawyers from each party present at the witness testimony. So the parties had to ensure that there were at least 2 lawyers present in every jurisdiction where witnesses were questioned. We had to rent conference rooms in hotels in several jurisdictions for months, because the hearing was was going on for a month. And there were other technical issues, like that you had to have 3 screens where you could open documents on one and court reporting on the second one, and then on the third one you will see the arbitrators themselves. And we used Microsoft Teams. Actually, it took quite a long discussion which platform to use, but in the end it was decided that Microsoft Teams was considered to be most secure from the secrecy and safeguarding of information perspective. And Microsoft Teams staff itself was controlling who was entering the room, because of course secrecy of this arbitration was one of the major issues we were all worried about. Were there accidents? Despite of the fact that we started preparations in March and the hearing was scheduled in summer, I would say that this hearing, given the complexity, was quite well organized. But there were still a number of accidents. For example, we had an online document sharing database, and it happened that one of the arbitrators, who was about 70 or 80 years old, uploaded his own notes there. I don't know how it happened, but one day it just appeared that arbitrators' notes from the hearing were uploaded there. There was a risk that someone would challenge it, or we would be compelled to substitute our arbitrator or something like that. But fortunately for us, the teams, the technicians were able to give us the safeguards that no lawyers, because they are able to see which party saw which document, and they were able to give us safeguards that no party representative had access to this document, because it was up for several hours. So there were the similar technical hiccups, especially when you deal with arbitrators who are not that technically proficient given their age and their experiences they have had in past, because hearing like that was quite unusual for them also. But in the end, all of them had this feeling that, given the circumstance and given what we had to deal with, they didn't have the feeling that the hearing would have been much better if conducted in person and with everybody being in the same room. What are my expectations in future? I think that a lot of bureaucratic steps would be probably eliminated from our institution's practice. For example, delivery and notice requirements. When everybody uses emails and document exchange is basically online, still having these rules that you have to actually courier the originals of the documents to the institution and to the second party. Probably we will see disappearing of these rules, unless, of course, one of the parties challenges the validity of the document and you need the original of the document for expertise or something like that, for expert testimony or something like that. But compelling a party to produce the original of the document will probably become rather an exception than as a rule, which used to be the case in our practice. I would say I expect that more and more hearings, at least on the case management conference level, would go online and virtually. But I do not believe that virtual hearings will substitute in-person meetings and hearings at all, because I, as a practicing lawyer, still have discomfort when I have to, question witness online, virtually. I mean, I think we all practitioners all agree that having an experience of questioning a witness in person is much more beneficial for the process and gives you some techniques and abilities which are simply not there when you do that virtually. So I think that what COVID has done, basically, I often say that COVID has accelerated the progress which was coming in any case. I think that we would see disappearing of this, sending originals of the documents and meeting people personally on everything. I think we would still see that, but maybe in 4 or 5 years and not this quickly. It's just COVID has pushed us to test our limits and understand what we are capable of achieving and doing when we are put under extraordinary circumstances, compelled that we don't have any other choice, adapt or simply stop working. And I think in Georgia, as all around the world, we have demonstrated the resilience and ability of legal community, and not only legal community, economy in general, but I'm very much proud of the legal community that we have done our best to continue working in the benefit of our clients, economy, and in general, did not stop working. And in the end, I think that I really think that the worst months are behind us, and 2021 will be much better. We are a bit smarter and wiser due to our experiences from 2020, and we will do our best to maintain the best practices we have adopted due to this compelled online virtual working habits we now have, basically.
Thank you very much, Tamta. This completes our presentations, and we're running a bit late, so I think we should open the floor to the Q&A as soon as possible. I just want to, follow up on Tamta's interesting point and maybe hear the others' views. There is an ongoing discussion whether remote hearings are easier to organize, whether they're cheaper, and whether they make sense, make life easier. And the pros and cons, depending on the case, depending who you represent, depending on the time zones, depending how well you're handling the technology as well, what you prefer. So I don't think there is an answer to this question, and if there is, please raise your hands, the speakers or the participants. But I think it really depends on where you stand and what kind of hearing you're looking at. I agree totally, Tamta, that any short hearings, any procedural hearings, I think they should be done remotely. And if they were not done remotely in the past, that will be the future, because it totally makes sense. But if you have a 3-week hearing or 2-week hearing, it is a big challenge. And I don't know, and I've been looking into it myself, whether financially it's cheaper. There is not a clear answer. It's possible that it's not cheaper, actually, because maybe in the future it can have some financial benefits, but when the lawyers and the arbitrators are learning how to follow the guidelines to set up an efficient hearing, they're spending a lot of time on that, which translates into money, of course, on arbitrators and lawyer side. And that is expensive, rather than them physically traveling somewhere, paying for the plane ticket and staying in a hotel. They're spending many, many hours figuring out how to make sure that the process goes smoothly and they understand that how this works. Also, you mentioned multiple cameras, a separate room. A lot of administration is involved in that. Does this make life cheaper? While in normal in-person hearing, you would just have one room and everybody would be in one room. Of course, you would have the breakaway rooms, etc. But still, here also you need breakaway rooms. And lastly, I think the point about the arbitrator uploading the notes is really funny. I hope it doesn't happen very often in real life, otherwise it would be a disaster. But I think those kind of technical glitches can happen. And then where do you go? Does this jeopardize the whole arbitration procedure because the arbitrator just made this mistake? And so much effort has been going on in this arbitration, and because of this one glitch, at least, you know, things can go wrong, and the award can be set aside, or a challenge of the arbitrator can start at a hearing or post-hearing stage. So there are lots of questions that we will be still asking and going forward. But of course, there is a certain benefit of the option of remote hearings and of the comfort, I guess, that we're increasingly getting with remote hearings when they're comfortable short, I guess, in terms of the duration. Now, I would like to address the questions that come. So we're getting questions here, questions that come from the audience. Kirsten, you mentioned one. Should we take that first, or there are a few lines of questions actually? So the first one, let's take it one by one, although we're running out of time, but I hope we can spend a bit more time because we started late. So first question, and I think Kirsten would be the first person to answer, and please others also volunteer. So how to interpret change in law in the construction infrastructure sector in COVID-19 pandemic situation based on the government notifications, etc., under common and civil law, and civil in international as well as domestic perspective. So that is the question, and then there's a continuation of this question, the context of productivity of resources, the same author of the question, how can we formulate it in realistic way, and what are the consequences? So that's a short, summary, and you can all read the question rather than me rereading it. So Kirsten, what do you think? You partially answered this question already, but if you would have any follow-up, and then I guess Tamta and all of us should participate in this discussion.
Thank you, Keti. A very good question, and I will offer, it's also a very broad question, covering many jurisdictions and many intricacies, but I would offer two further comments at this early stage. First is just to confirm that I do think change of law is an effective avenue for claims, and it's one that parties should consider alongside force majeure. And so I think when you're thinking in the context of what kind of claims you can bring, change of law is a very good claim. So in order to develop the claim as you would with any claim, you need to be able to assess and track what are the changes of law. And then the more difficult piece, which is where the productivity part comes in, is assess what are the impacts of those that change in law has had. And that's, I think, where it becomes quite difficult, and we require a more creative approach in assessing the impacts. So if we can take maybe just one example to facilitate the discussion, which is the supply chain example. If there are, I know, for example, restrictions on travel. So if a government places restrictions on travel, so for example, the European Union doesn't allow Canadians or Americans to travel into the European Union at various points during this year. What if you needed labor or you had individuals working in those countries, and what are the impacts on your project? So I think that's sort of the way to conceptualize it, is like to identify the precise law and the impacts, but there are many case-specific circumstances that one would of course take into account.
Thank you. Does anyone have anything to add on this, which can be a very long discussion, of course, on its own?
I just have one note on that, and maybe it relates to other questions which were coming also, especially with regard to force majeure. But to continue what Kristen just said, it is tempting for the lawyers to, go to the force majeure clause every time their clients have problems in complying with their contractual rights and obligations. But the matter of the fact is that the regulations in various countries have very, very different, and most times it's hardship rather than force majeure. So it's not impossibility of to perform your duties. It's just performing your duties may be a bit delayed or a bit more difficult. So I think that there is definite temptation to rely on force majeure circumstance on everything, but it needs to be carefully evaluated whether the business or the contract in question was impacted so directly and gravely that it indeed qualifies as force majeure. So here I think that the lawyers need to be very cautious, and maybe changing law or some other remedies would be more adequate for them to rely on rather than force majeure clauses.
Okay. Thank you. So there is a note from one of the participants, the same actually participant. He says that I guess he's responding to our discussion about how difficult sometimes it is to conduct things remotely, and it's impossible, and with witnesses it might be very difficult. He says it's right that the experts should visit frequently the site. Yes, I guess that the experts cannot do everything remotely, and there's situations that of course certain experts just cannot sit at home and opine. Sometimes even members of the tribunal go and visit the site, and now it's impossible, and in certain circumstances it's very important. Usually when they do and go and visit the site, it means that it is a very important factor for the case. So yes, that cannot be done. There are a number of things that we can think about what cannot be done if you live life remotely, and that will complicate things, and maybe parties due process as a result, because parties could not have presented the case because of these restrictions. Now I move to another line of, so we have two lines of questions, and that is, does the ICC and GIAC envisage more ease on doing business initiatives from the Georgian government? So that is a general question, and unfortunately we do not have anyone from the Georgian government here. So it just has to be a personal view if we have the views expressed by the speakers. And if yes, the question continues, will GIAC be default institution for Georgia investment disputes? Beka, I will let you respond to this. I guess you're the closest.
Yes, thank you, Katie. Also very interesting question. And from our perspective, and maybe Hordis will agree on that, that from very corporate point of view, from GIAC corporate point of view, of course, we would love that GIAC would be the default mechanism of dispute settlement. But from very pragmatic, and also from the point of view of practitioner, private practitioner, as I'm doing, and we as a GIAC, as a policy, as a base of policy, we are thinking that the default in this case, if the state will make the arbitration, GIAC arbitration clauses, for example, or one arbitration institutional clause as a default as its dispute settlement mechanism, I think that it becomes not a private arbitration setting, it becomes a statutory arbitration in general. So I think that we have experienced that the Georgian government itself includes in some the investment contracts the GIAC if it is necessary, and of course the balanced approaches is most appropriate thing. I think that it is right thing that it should be balanced. So case by case, users, states, parties, they should use the clauses. For example, if they will need ICC and they think that ICC is the appropriate one in international cases, they should use ICC, or they can use the regional arbitration centers. It's up to the cases, up to the needs of the clients, the parties. It's up to the needs of the states, and you know that the state, it is not a ordinary party of the contract. It is state, it is public law is involved in this, and there's big interest, public interest, so there is another rule. So in some points, state is not such free to make decisions to include the one or other institution. So it should take in account all relevant circumstances to include the dispute settlement mechanism. But as for the question, I will turn to the business. I will read it out. The doing business initiation. Yes, in doing business initiation, I don't think that the going on the arbitration and the choosing the institution, it will help it. Of course, the great, good and effective and the credible arbitral institutions, it's good, of course, to have in the country, but I think that it is something private sector, it is not something the court should, the state should take because the state has courts there. So arbitration is much private, so and the state can use it in any case when it thinks that it is appropriate to include in some or other contracts or investment deals. So maybe I answered my question appropriately.
Thank you. I think you have, if there is a follow-up question, I invite the author of the question to elaborate, and then we will address them in a conversation, answer, and question format. In the meantime, there's a question to Tamta, who thanks you for the fascinating experience of virtual hearings that you have shared, and here the question, the person would like to know if there is any litigation support service or consultant was used to prepare for the hearing. I think that is interesting. Tamta, please respond. And then I have a follow-up question, whether arbitral institutions are helping or have helped, at least at the beginning of the pandemic, with organizing the hearings. And then I would like to hear from Yordis and Beka. Thank you.
No, in our case, no such service was used. We had certain IT consultants and IT support, but this was narrowly tailored to IT issues and not in general. I mean, how to organize the virtual litigations or hearings. As regards your question, Katie, yes, I mean, we saw even from the very beginning until there was specific protocol or rules or approaches from the arbitral institutions, there was willingness to cooperate and help to an extent possible, at least technically, in how to deal with this issue. And GIAC was quite prompt in actually elaborating the protocol on virtual hearings, which was not part of the rules, as I remember, but at least an official document to serve as a guidance for the parties as well as arbitral institutions, how to deal with the technical issues when it came to virtual conferences and hearings. So I think that as all of the participants today mentioned, arbitral institutions, although they are often described as conservative institutions, were quite quick to adapt and react to the realities of the situation in 2020.
Yeah, that is true. But my question is, even did the arbitral institutions, at least at the beginning, ICC, I'm wondering, provide the platform physically to hold a virtual hearing?
Yeah.
Because GIAC, I know, has this platform. Did ICC have a platform where the hearing could have been held?
We did not have a platform as such. We just had our ICC Hearing Center, and they offer virtual hearing services. And then we have memorandums of understanding with some hearing centers around the globe, where we can initiate contact and provide support between the parties and that hearing center. But, and Laetitia, please add something if I'm missing something. There was no ICC platform as such, but just our hearing center provided the support for virtual settings.
Great.
Exactly, they arrange everything, and they were quite pioneer at the beginning to organize everything, but there is no specific platform as such.
Thank you. This was my understanding, but I wanted to confirm, and also for the benefit of the participants, so they know this practicality. Last question, and I think we can discuss this a bit. This should not be a very short discussion, although we're already late, but still, it's very interesting. The question is whether the virtual hearings can result in challenging challenges, and for me, challenges of due process grounds when the award would be challenged. And also, I have recently seen 2 days ago there was an exit case, which is a good example, although this is not a subject of our discussion today, that the party tried Spain, the respondent, there was a case against Spain, the respondent tried to unseat the tribunal because they refused to hold the hearing in person. And the two, so they wanted to unseat the whole tribunal, 3-member tribunal. So there were 2 issues. The tribunal members said that they could not hold the hearing in person because one of the arbitrators was based in Costa Rica and he could not have traveled because there was a ban on travel. And then the second one, the other arbitrator was ill, was supposed to undergo a physical surgery in England, and then he would need to go through the quarantine afterwards. And if he were to leave, he would need to go through the quarantine coming back. And he was not in the best health state at the moment to go through those quarantines in parallel. So this was taken as a very good quote I want to take, that the respondent argued, if I may find this now, or I'll find it in a second. Basically, the respondent said that Spain said that this was speculative and misleading, the arguments that the arbitral members provided for not traveling, and demonstrates, I'm quoting Spain, that the tribunal prioritized their private interest at the cost of states' basic procedural rights. So that's a very interesting balancing exercise that the respondent or the party that's opposing to the personal hearing, virtual hearing, has made. So it's very interesting. Going back to the discussion, as I said, the first point is, does the virtual hearing constitute a future potential ground to challenge the award? I personally have not seen any arbitral rules, and we've discussed the ICC, so I won't go back to it and GIAC, but I haven't seen any rules which prohibits remote hearing. So the party would not have a reason to say that it is prohibited by the arbitral rules, and the tribunal still ordered a virtual hearing. Or I haven't seen any case law that also any laws from different jurisdictions that also prohibit this, or any actual court decisions setting aside, and correct me if I'm wrong, setting aside an award purely on the ground that the hearing was done remotely. To the contrary, I think there is the general understanding that the hearings have to be done as the circumstances permit, and not to have the system delayed. And that reminds me of a very interesting Australian court decision, which was the party wanted to oppose to the remote hearing in court. It was not an arbitration case, and the Australian judge went through a number of issues that the party had raised, which was examination of the witnesses and the documents, and there were lots of issues that, a laundry list of objections, and the tribunal dismissed, the court dismissed those, and saying that yes, but in the given circumstances, okay, it's not ideal, but it still makes sense to do it remotely. So I wonder, and I would like to hear from everyone, what are your thoughts about due process violations if the hearing is held remotely, as opposed to in-person hearing in any context? So you can bring in different jurisdictions and different points in discussion. Thank you. So I have to call out, I think, on the Beka, you're smiling too much, so you should be the first one to answer.
Actually, I wanted to say the same, that you have to nominate the first who will answer this question. A question is not easy, and maybe the main challenge, this is the main question in this year, and actually to refer to our side, and I have not heard in Georgia from our practice that this question has been so far referred or has been discussed in the court, or maybe by the arbitration. I don't know, but there can be, because we are an institution, we are trying much to have get here what result has happened after the award has been rendered, but we don't have full access of what happened afterwards. But anyway, we sometimes hear if there was the action of annulment, set aside, or what happened during the recognition and enforcement. But so far we don't have any, from Georgian perspective, I mean, we don't have any examples that the court has discussed the issue of the due process during this in connection with the distance and the distance remote hearings. But my point of view, of course, I like the balanced assessments and everything balanced and not radical or something. So I think that everything is case by case. So if there has been the irregularities during the remote hearings, if actually the tribunal or the parties has not enough possibility, real, and it is a fact that they did not have the possibility to presented cases, or there has been the really reasonable filings or a reasonable argument that the arbitral hearing should be postponed or whatever. If there is, then there is a very reality and explicit, then I think that, of course, it doesn't matter it is virtual or it is in person. If there is such kind of violation, then there this question is. But in such remote or distance hearings, it, from my perspective, is maybe personal. So in general, not paying attention to the details. In general, I don't think that the remote and the distance hearings, it raises the question of due process. Maybe it is the shortly, I will stop here, not continuing to give the floor others to give their opinions.
Thank you. I think it is very important for the arbitral institutions, as much as they can, ensure that the balance is struck and the parties don't go afterwards before the court. The party doesn't go before the court and try to challenge it. And one of the ways, I guess, what the both institutions, ICC and GIAC, have achieved is providing the guidelines on time and kind of hand holding when the whole world was so confused, how to go forward without challenging the due process violations. That would have been, things would have gone wrong very easily. And I want to thank the arbitral institutions for that they actually thought about it and made sure that, you know, by providing guidelines very quickly and technical, you know, lots of instructions to the parties, they made their made things as safe as possible. And I think going forward, the lot will depend on arbitral institutions in institutional arbitrations. A totally different question is ad hoc arbitrations, but we're not going there now, to make sure that they're doing their best to maintain due process as far as they're concerned and their rules and their guidelines are concerned. Thank you. Now I would like to ask Hjördís, unless you have a follow-up on this, please let us know, and then it will be Kirsten I would like to hear on this.
No, I just wanted to say that in most of our cases where we've had virtual hearings, it's been with both parties' consent. I did find in my research 2 cases where one of the parties objected and the tribunal nevertheless ordered a virtual hearing. In one of those, the claimant party requested a virtual hearing. The respondent objected for a number of reasons. They argued that the case was not well suited for a virtual hearing. It was too technical, too complex, too sensitive. They argued that witness testimony might be at risk on a virtual platform. They also put forward the argument that they had participants from 10 or 11 countries with 7 or 8 different time zones, with a 14 or 15-hour gap in terms of suitable timing. But despite all this, the tribunal decided that to proceed with a virtual hearing. Now, of course, we don't know whether then this will ultimately lead to a challenge or not. But the tribunal argued that none of these arguments actually posed any due process concerns upon closer review. And actually, I don't know, maybe people are aware of, there was a judgment by the Austrian Supreme Court in July, which you may have seen, where there was a GIAC arbitration that was conducted virtually, and there was a challenge against the tribunal that was rejected. So we do have, I mean, it's one jurisdiction, one court case, but some reassurances that provided that, you know, it's a reasoned decision by the tribunal, and all comments are taken into account. You know, I think we have at least some assurances that it should be okay on that basis.
Yes, thank you. Kirsten?
I think the two previous speakers covered the key issues. For me, there's no per se reason not to proceed with a virtual hearing. It's about the implementation, which is exactly what Beka was talking about. And I think that's where the guidance from the institutions is invaluable. And I also think conferences like this, where practitioners like Tamta shared their experience in sort of the do's and the don'ts of how to ensure and guarantee due process within the context of the hearing. It's not one size fits all. There'll be a lot of, you know, adjustment that needs to be done. And I think that from a practitioner's perspective, in addition to your own craft of how you convey arguments orally and how you cross-examine witnesses in a virtual world, that requires refinement. But the other key issue, I think, is safeguarding the, you know, as Tamta did with having lawyers present with the witnesses. Is that possible in all cases? How do you ensure that they're, you know, not getting assistance or not checking notes or being given some information in the chat box about the answers to the questions? And so I think that that's sort of a key issue. And then the second key issue is the consent issue. And I've had some experience similar to what Hortis was talking about. What can a tribunal do in the face of one party's resistance? And I think there's all, you know, all kind of ranges and spectrums, but that's where I think there's a potential for additional jurisprudence about challenges to develop, is that situation where one party has refused for whatever reason and the tribunal has decided to proceed. And so where you don't have that meeting of the minds, I think that's sort of where the risks are. And that's really where I think the institutions and the practitioners and the tribunals need to think very carefully about how to safeguard due process in such circumstances and how to protect the ward, whether that is, as Hortis just said, through reasoned decisions, you know, explaining the process and documenting how it was developed. And I'll leave it there.
Thank you. Thank you for all your comments. Tamta, I would have a specific question because a lot has been covered on this. Do you anticipate and imagine that a case goes before a Georgian court challenging the award because the hearing took place remotely? And I understand that has not happened yet from Beka. Imagine that happens. How do you think Georgian courts will look at it? Do you think, I want you to speculate, of course, and do you think different instances of Georgian courts will have different approaches? And do you think certain instances are within the Georgian judiciary more arbitration friendly than the others, and higher it goes, more chances of supporting remote hearings will be?
Thank you, Katie, for your question. The matter of the fact is that we have virtual hearings in courts also, but then the practice of judges really varies. There are judges who think that, you know, if one of the parties object to virtual hearings, they have to either postpone the case or ask both parties to come. There are judges who simply do not recognize virtual hearings. And then there are judges who simply order virtual hearings, notwithstanding what the parties want, basically. So we have this variety of approaches in Georgian courts, and there is no uniformity in this regard. Given my experience with Georgian judges, they used to they sort of tend to treat arbitration and arbitral proceedings from their perspective, from how they view things in general. So in recent years, Georgian courts actually have become due to Beka's and others' extensive efforts, remarkably arbitration friendly. However, we are still seeing cases where they sort of struggle to understand what the arbitration and the relevant proceedings is all about. So if you ask me, I would think that with high probability, they would honor the decisions made the arbitral tribunals, meaning that, you know, there was no prohibition in the rules of GIAC. There were really extraordinary circumstances, and merely the fact that the hearing was conducted virtually probably would not be considered as violation of the party's due process rights. The party has to go beyond that, and the party challenging the award really needs to demonstrate that by conducting the hearing virtually, it was indeed deprived of its ability to adequately protect its rights, and whether the party will be successful in doing so or not really depends. I mean, it really depends how the institution in question handled the case. From what I have seen in GIAC, probably the party will be less successful. In case of other institutions, I wouldn't be so sure. So, I mean, from practical perspective, we have signs in Georgian courts' decisions and conduct and how they operate themselves to have the assurance that if somebody goes to the court and challenges the award, but relying merely on the fact that the hearing was virtual, probably they will not be successful. They have to have arguments beyond that.
I think all of us agree from different perspectives, from different, wearing different hats, that merely the fact that the hearing is conducted remotely is not enough to convincingly, successfully argue due process violations. I think it should depend on a case, how the tribunal has handled it, how the arbitral institution has helped the parties and the tribunal to conduct the hearing fairly, and a combination of those factors would probably allow us to make a more informed judgment of which way to lean in deciding whether there are chances of challenging a remote hearing or not, but not on the basis of a sole fact that it was remote rather than in person. I guess that is our takeaway from this discussion. I want to thank everyone. I believe we have exhausted all the questions and have discussed those questions in detail. And I think we should finish here because we're half an hour late because of me, of course, and I apologize again for this, but I think it turned out to be an interesting discussion and interesting conference. This is the last conference of GIAC this year, and I believe the last conference in the region on arbitration. So this completes our work virtually, and I want to thank everyone, and I want to wish everyone happy holidays in their homes this year. Thank you very much. Happy end of the year, and let's look forward to a more interesting year, 2021.
From my side, of course, I'll join to Katie, and also will thank to all of the participants, and many thanks to ICC, Laetitia, your effort, and of course, wish you best holidays. And also the main is that the next year I wish that we don't have any pandemic and some this disease and everything good. And I think that for us, for our organization, we will continue our tries and efforts to develop arbitration in whole world, and we are have this good experience. Thank you from my side.
Thank you, everyone.
Thank you all. Happy holidays.
Happy holidays. Bye.
Holidays to all.
Thank
Bye.
you.
Bye.
Bye
Thank you,
bye.
Katie.
Bye bye.
Bye.